We're back. Today we're going to talk about the recent executive orders issued by Donald Trump that eliminated DEI and DEIA, diversity, equity, inclusion, and accessibility. Now, the reason I want to talk about this is not to rehash what the orders are for, not to rehash the impact, but to talk about two things specifically. There were two cases filed in relation to the executive orders. And I want to talk about the difference of those two cases today and why I believe one case will be more effective than the other. Now, I could be wrong, and I hope I am, but based upon what I read, the two cases brought are pretty different in their approach. Not that we all have to do the same thing. However, back in the 50s, when the NAACP was bringing the Brown versus Board of Education cases, they had multiple cases in multiple states, but they all had specific similarities to them in order for the NAACP, Thurgood Marshall specifically, to understand what was working and what wasn't. And so this is why I want to bring up these two cases today. So the first executive order specifically targeted federal government activities aiming to end discriminatory programs, including things like equity-related grants or contracts. The second executive order issued the next day focused on ending illegal preferences and discrimination in both the federal government and the private sector. This is important because federal laws are broad. And so when you impact the federal government and the private sector, you're in essence impacting everything. The one thing that both executive orders did not do was define what DEI, what equity related or illegal discrimination actually meant. And this is going to be important. And this is why, again, I say that one of the cases filed is going to be more impactful than the other. So let's get into that. The first case I want to discuss was brought by four different organizations: the National Association of Diversity Officers in Higher Education, the American Association of University Professors, the Restaurant Opportunity Centers United, and the Mayor and City Council of Baltimore. So without getting into the legal weeds, let me summarize the court's findings. One of the findings was that key terms of the executive orders were not defined. Again, DEI, the equity language, those things have to be clear, because if they're vague, they can mean anything. And that is not something that the courts generally will accept, even in laws passed by Congress. And many laws get passed by Congress without defining certain terms that become important later when someone actually sues based upon their version or based upon their understanding of the Constitution and what it means. The court also mentioned that the executive orders and basically overregulated speech or prevented people from talking about things that were protected speech. And when you have something like that, you run up against the First Amendment. And courts are generally pretty flexible and pretty lenient when it comes to a person's ability to speak on things that are of importance to the public, to the community, regarding things like diversity and inclusion, about race, about disabilities, about gender. The courts are not going to restrict that type of speech just because someone wants you not to talk about it. You have to have a really good reason in the court's mind to restrict that type of speech. Three, two, one. The court also was concerned about the irreparable harm that the broadness of these executive orders would cause in disrupting people's speech and other facets of life that people were so used to and that were, in essence, taken for granted as our constitutional rights. But the executive orders also talked about restricting funds. That's irreparable harm. People need money from the government at different times. Schools need money from the government to operate. And if that money's all of a sudden cut off without warning, who knows what could happen? A lot of calamities, a lot of issues. Hospitals could be losing money. There are a lot of things that the court is trying to prevent. And one of the more important parts of the ruling by the court is that the remedies extend to non parties. So that means people like you and me benefit from the case brought by those four groups. So that's a high level discussion of that case. Now, the other part that's very important is the timing. So the executive orders by Trump were issued roughly January 20th and January 21st. So that first case I mentioned was actually very interesting in the way it came together. The executive orders were issued roughly January 20th and January 21st. The filing of that first case was February 3rd, which is roughly 2 weeks. That's a very quick turnaround to receive the executive order, determine you don't like what it says, find like minded and similarly situated plaintiffs such as yourself, find a law firm to take your case, and then file the case. It's almost unheard of, but it's happened before. But it's not an easy process, and it takes a lot of work in a very short period of time. So I applaud those groups. And I'm going to say this: out of the four groups I mentioned for that first case, had you ever heard of those groups before? I've heard of the mayor of Baltimore, but the other three I'd never heard of. Now, in the second case, you had the NAACP Legal Defense Fund as the attorney. You had the National Urban League as a plaintiff, the National Fair Housing Alliance as a plaintiff, the National Fair Housing Alliance as a plaintiff, and the AIDS Foundation of Chicago as the third plaintiff. Now, this case took longer to actually coalesce and get filed. Again, February 19th. What's also interesting about this particular filing is that it didn't target specific provisions of the executive orders, as I mentioned, the other case did. Now, they don't necessarily have to, but in my opinion, if you target the language specifically, if you target certain provisions, then even if you don't get a full 100% ruling, you might start to chip away at the legitimacy of that executive order. Now, what did the second lawsuit ask for? So the second case, the attorney for the case is the NAACP Legal Defense Fund. One of the plaintiffs is the National Urban League. The other plaintiff is the National Fair Housing Alliance. And the third plaintiff is the AIDS Foundation of Chicago. This case is different. This case is more high level. This case doesn't go into detail about specific provisions like the other case did. Is that good or bad? The court hasn't ruled on this case yet, so I don't know that yet. But my personal preference would be to target specific provisions and to target specific language. So once the ruling on this case is issued, we'll have a very good sense of which approach, at least in these two instances, was better. Now, will this case have an impact that contradicts the other one? It's possible. So it could be that the court in this case doesn't have such a broad ruling and says it should be more limited. That would cause a difference between the circuits, and that would definitely raise an issue on appeal. It would make the federal courts and the federal agencies in these different jurisdictions not sure which one to follow. So all that being said, should we file more cases? At this stage, I think it's too early. I think these two cases right now are enough. Other people can differ, of course. But I think I'm applauding the first case because they came out quickly, they came out effectively, and they got a ruling quickly. And the ruling was in their favor. And they targeted specific provisions. They were surgical, they were strategic. Not to say that the second case is not, but it did take a bit longer to develop, and they weren't as specific and they weren't as surgical, in my opinion. Doesn't mean they won't get a good result, doesn't mean they're going to get a bad result, just laying out the differences. So stay tuned on these two cases. I certainly am, and let's hope they continue to go in our favor. Be well.